whether the court was on notice. And I just want to clarify, in the state's original letter of intent that we've discussed before, this is from 2020. The state indicates in its letter, for years, defendant had transferred money from the TD Trust bank account into his personal bank accounts. Defendant paid the monies back to the trust account, completely in 2014 and mostly in 2015 and 16. In 2017 and 2018, though, that's where the unauthorized takings are alleged.
Okay, pause for a second. This is where it gets messy. The defense is laying out a timeline from 2014 to 2018, but the prosecution says only 2017 and 2018 matter. Why? Because that's when the alleged thefts actually happened. Everything before that, the defense claims it gives context. The court, not so sure.
So that was originally submitted, like it was out when I came into the case in January. I had this letter and this letter only. It was my understanding that this case was about 2014, 15, 16, 17, 18. And then we filed a response, and Your Honor signed an order. And in the order, Your Honor recaps the facts of the case. And this is on page 12 of Your Honor's order, and says the letter emphasized that the falsified records would be used to show defendant submitted fabricated statements, and that the timeline of the financial conflicts between the brothers stretched from 2016. So I think Your Honor is referring to the facts alleged that I just read from the letter. And then Your Honor finds ultimately what's admissible is it includes 2000. It includes that time period. I think it's on page 63. So
notice what just happened. The defense is arguing that earlier repayments show good faith, basically saying he paid back money before, so he wasn't stealing later. But legally, that's shaky ground. Prior good behavior doesn't erase later alleged crimes. The judge is about to pounce on that logic.
It was our understanding all along that
includes
was the
what years? 2017 or 16?
16. But that was based on the facts that Your Honor was summarizing from their facts, but their facts had 2014 and 2015. Then we filed the motion for, that they needed an expert to present this testimony, and that's when we said, look, we have 50 reports from Detective Bassender. The information needs to be synthesized so we know exactly what they're relying upon. And then in July, the end of July, is when we received her expert report. And that's when we learned for the first time that she might only be testifying to 17 and 18. But that doesn't mean that we weren't under the impression this entire time that time period was relevant. Obviously, a defense to theft is money was paid back, money was paid back, money was paid back. And then the indictment focuses on those 2 years because that's what they're alleging. But it doesn't mean that the entire time period isn't relevant, nor that it wasn't previously discussed in the state's own facts.
Here's the problem that I have. I'm going to say you, but it's your team. The defense had no problem with filing whatever amount of motions they wanted to file. I gave everyone the opportunity to file them. I then, after...
And there it is. The judge hitting with a classic analogy. Doing 50 things right doesn't justify 5 wrong ones. That's courtroom gold. What do you think? Should a person's history of paying back funds matter? Or should the court only focus on the years tied to the charges?
The Supreme Court got involved in our case. I specifically asked if there was more to discuss. By then, you have the July report. You have all the opinions by the court. If there was clarification that was necessary, we could have clarified it. We're now in the middle of trial, in the middle of a witness, with jurors here, and the state's only providing 17 and 18 based upon what the indictment is. If you want to go into 14, 15, and 16, I get it, but that's not where the theft is. So, to me, I would think that you would need to have to give me something to support the fact that because he paid in 14, 15, and 16, that means that he's good for 17 and 18 because, maybe he would have paid it back, or I don't know what you're going to try to insinuate. But the reality is this. I mean, I don't know how else to say this. Just because somebody does 50 things right in their life, if they then do 5 things wrong later in their life, that doesn't mean that the first 15, 20, 50 things, whatever they are, that are right, means that that's a justification for what happens later.
At this point, you can feel the tension rising. Both sides are pushing the limits of what's relevant. The defense wants to widen the lens. The judge wants to tighten it. This back and forth isn't just about years. It's about control, the narrative.
And I think that's what you're trying to say. So, to me, I'm more than willing to listen. I'll work it out with you guys. But I'm just saying we should have been filing motions if we wanted to bring in something. The indictment is all that we should be talking about is 17 and 18. If the state started going into 14 and pushing all of this other stuff right now as a part of their bad acts towards 17 and 18, you guys would be standing up complaining about the fact that you're going into other time frames so that Paul Caneiro knows what he's doing when he's not paying them back. So I just want to be very careful. I'm willing to listen. I've said it 1,000 times. So far, all I'm saying is that what I've just seen here today, we have gone well beyond the direct. Nobody has said any objections, so I've let it go. But we're going into areas that, to me, I'm not sure that we should be in. If we're going into them, if both sides agree, so be it. If you guys want to agree to that, go ahead. But to me, the indictment is the area of where we're in. My opinion may have talked about those dates because it was within that motion, but the indictment's still the indictment. So that's the area that we're playing in. Ms. Mastalone, I'm going to let you finish because you started before I let Mr. Decker say anything. Go ahead.
No, just the only point was that this wasn't a surprise to anyone, and the 2014, 15, 16 timeframe was in the state's original, hey, this is what we may intend to present at trial. We were on notice of those years. We assumed those years were encompassed. Just because they provided an expert report in the late July for a September trial date that didn't include the rest doesn't mean that we were under the impression that it wasn't relevant. Of course it's relevant. In fact, it's interesting that originally they acknowledge monies are paid back, monies are paid back, monies are paid back, and then they're like, oh, but we might not talk about that. We just want to talk about this. And that's, concerning, but it's relevant.
But there's parts that weren't paid back between 14 and 16, right?
Yes, and we went into that, so we were fully forthright about that.
My point only is that the decision was made by the state to not start the indictment in 16, 15, or 14. They made a decision, or the grand jurors made a decision, to start in January of 2017. So, to me, going back 14, 15, and 16 has nothing to do with what happens in 17 and 18.
Quick breakdown. The prosecution's now clarifying that any old letters or filings, like that 2020 notice of intent, don't carry much weight anymore. Basically, 5 years later, those papers are courtroom fossils. What matters now is the indictment, the official document listing the charges.
Unless somebody's tying it in. And just because the state put that in that notice of intent, I had to make the determinations of what we were going to talk about, and I was looking at the confines of the indictment. But let me hear from Mr. Decker.
Judge, just for the record, as far as the notice of intent that we filed in 2020, and I'm not going to rehash this, but it just has to be said, that document is completely meaningless at this point, because for 5 years we were under the impression, and the defense was asked numerous times, are you going to file any motions, are you going to file any motions? We all know things change. I've said it a million times. I don't blame Ms. Mastalone. I don't blame Mr. Murray. But that document's value is...
That moment says it all. Even the judge admits, if I got lost, imagine the jury. When a case gets buried under years of filings, letters, and financial dates, clarity becomes the real victim. And that, folks, is where courtroom communication can make or break a verdict.
A little bit sketchy at this point in time. That being said, I just wanted to clarify one minor point. I'm not trying to go anywhere with it, but one of the things that we said at sidebar with respect to that objection about when the court was talking about speculation and the like, is I think the point I was trying to make was that I thought Mr. Murray had asked the witness about the Keith Caneiro irrevocable trust agreement that was faxed, the copy of it that was faxed to TD Bank, the one that was missing page, I think it's 6.
My understanding of the question dealt with where did it come from? How did it get there? Maybe this person, it could have been this, it could have been that.
That was part of it, Your Honor. But I think the last question that spawned the objection was intimating, or at least asking, whether, basically saying that Paul Caneiro did not know that he was a beneficiary of that trust, despite the fact, the first time we ever heard that, but also despite the fact that he's the trustee and he signed it. I believe that was the point they were trying to make. So I'm just clarifying that. We're past it, I think, but I just wanted the court to understand. I believe that's what the question actually was.
Well, let me just say this. If I got lost on the question, God only knows on what's going on with the jurors as they're listening to this testimony. Go forth as you need to go forth. Again, I'm not slowing anyone down. Just think about what you're doing and how you're doing it. All right? So, look, Mr. Decker, let me be abundantly clear. Are we getting into documents from 2014, 15, and 16? The defense is basically saying they want to bring all this stuff in. Are you of the position, you and Ms. Wallace, no disrespect, you can stand up and answer too. I don't care. What are we talking about? Are we talking about all the documents? Are we talking about 17 and 18? What are we doing?
Our direct was limited to 17 and 18, and that is what the state is talking about. I don't see how the fact that the defendant may have paid back monies to a trust account in 2014, 15, and 16 is relevant to what he did in 17 and 18.
Okay. You've now heard it. If you guys have a position on that, you want to supply me with something as to why you feel the need to go further, you already have. But if you want to do it...
Done, Judge. I was just completing the record because it had appeared that you were saying to Mr. Murray, like, the court wasn't aware that 14, 15, 16 was a thing. It was a thing because it was in the original letter. That was all. That's the point. So it's that it wasn't a big surprise today. There's been a lot of litigation in this case already. It was a while ago. It was earlier last year when we handled these motions in March, April, May. So I understand that it's been a while, and I was just trying to show that this was something that was addressed previously at this time frame, and it's done. We're done. There's nothing more.
Okay.